All right, so welcome to 60 minutes of civil bills and other things you never knew you cared about, but it's my job to make you care about it. What I've tried to do here is give you a sampling of bills that you may actually care about in various things that might be relevant to you or the people you work with. For the county attorneys, some of these are specific to you to advise your client agencies, but I've tried to come up with things that you guys will be interested in. Now, there are a few ground rules for this presentation. I've decided to go very low tech because I realized at Train the Trainer that I had not done a presentation to any size group in 6 years without using a PowerPoint. And that seemed like, and that seems like a massive crutch, right? So I was like, you know what, I can do this without a PowerPoint. So you guys are the lucky or unlucky recipients of my test of a new style of training, which is very interactive, which does involve prizes you will see on this table, and also snacks. I realize you guys have a lot of snacks, so you guys might not want that, but it's a lot of fidget spinner kind of prizes, but it requires you to participate. So what you'll see I've done, there are 6 categories of bills up here. I'm going to call on you, or you can volunteer, and you choose a category of bill. Then I'm going to take it off, and there's going to be a number of Post-it notes underneath it, giant ones, with bill numbers on it. If you choose a bill number that has a sticker underneath it, and at least 2 on every page have a sticker underneath it, oftentimes 3, you get to choose from the prize collection, right? We'll then talk about that bill. Underneath all of the stickies on each page is a letter. The letters spell out your message for today as you leave. So the more of the stickies you take off, the closer you get to solving the puzzle. Whoever solves the puzzle of what the message is gets a special prize that I will have to send you because I haven't figured out what it is yet. But that's where we are. All right, so starting with, I hear we have a prosecutor from West Valley City who has been a prosecutor for 5 days. And I think that's the most recent hire in the room, correct? Anyone more recent than that? All right, new hire, please say your name and choose a category.
Yes, my name is Sean, and let's do behavioral health.
All right, behavioral health. Now, you get to choose which bill we're going to start with. Which bill are you going to start with?
Is it SB 41? All right.
SB 41. Let's see if you are a lucky winner. No sticker for you. I'm really sorry. All right, but let's go to tab 4 in my binder, and that is item D. All right, so this SB 41 was from Senator Kennedy. It was called Behavioral Health Services Amendments. This is actually a really interesting thing for the counties, and that is because I'm going to set my binder up here because it's a little easier to flip through on this thing. It requires the Department of Health, the State Department of Health, to develop to grant a local mental health authority. Do y'all know what a local mental health authority is? Yes, I see lots of nodding. Excellent. To implement or expand integrated behavioral health programs and appropriates $116,000 ongoing and $87,000 one time to fund the grants. So if you have a good relationship with your local mental health authority and you think that they should be looking into areas of integrated behavioral health programs, look at some grant opportunities because that could be free money to your county. It also requires the Department of Health to develop a proposal and apply for a waiver to allow the state Medicaid program to reimburse local mental health authorities for physical health services in an integrated healthcare setting. And that's what that means is that when you have somebody who has behavioral health needs, but they also have physical needs at the same time, which as lots of us who have dealt with people who benefit from behavioral health services know, those things often go together. What they're going to do is apply to Medicaid for a waiver to allow the cost of the physical care to be reimbursed by Medicaid. And that can make a huge difference, again, to your counties and your behavioral health programs, because if Medicaid is willing to pay for things, that is money that is not coming out of your budget. I will tell you, I'm a little bitter, and I see some folks from the state here, a little bitter because we finally did get the state a few years ago after literally I tried to do this for 3 years. We finally got them to pass a bill that required the state to submit a waiver request for Medicaid to pay for inmate medical services in the last 30 days of their stay in jail. And they did it, but they did it only for state inmates. And I swear to God, that was not my intention when I fought for that bill for such a long time. I really thought it would make a difference to the counties because that's a real cost to the various counties. And I'm hoping that if it does get, if the waiver is approved and if they go forward, they will eventually expand it to counties. But hopefully when the state does this one, they will include both state facilities and county facilities. We'll have to see. All right, who's next? Rod Van Dyke, choose a category.
I'll do the same category, HB 261.
All right. Rob has also not a sticker. I'm really sorry. I swear, at least 2 on each one. So anybody else wants behavioral health, you know where to go. All right. So that is going to be civil commitment revisions. Representative Lyman. So has anyone here dealt with civil commitment? Lots of people I see. It is a frustrating system, right? All this does, but this is a pretty big change in how it is. In order to get somebody civilly committed for 24 or up to 72 hours, and that's a different bill we can talk about, that's actually in 363. In order to do that, you need somebody who can certify that they meet criteria for civil commitment and they need to be held for a certain amount of time. This adds physician assistants and nurse practitioners to the list of people who can act as designated examiners. That's a really big change. It was a little controversial for the people who had historically been able to serve that role, but this is a big expansion. Of course, it doesn't expand what happens when you do get someone civilly committed, but it does change who all you can go to get that certification. All right, who's next? Anyone want to volunteer for a topic? Jeff Buman.
HB 236.
Okay. I see a reindeer for Jeff. Jeff, you can choose your, I know you can't see it, they're tiny. I was cleaning out my son's sticker drawer while I was doing this. I ran out of all the My Little Ponies, so instead you guys get forest creatures. So Jeff, you get a prize. They're all up here. You can choose it now or you can choose it later, but you are entitled to the prize of your choice.
I'll look for the Maryland, so she get my prize.
She's going to get your prize?
Yeah.
All right. So this is behavioral health amendments. Or Rob can throw it to you. I asked Rob to be in charge of throwing things at people because if I try to throw things at you, you will not appreciate it. I also might not get to you. So HB 236 creates a collaborative care grant program administered by the Division of Substance Abuse and Mental Health, which is in the newly constituted Division of Health and Human Services. Small primary health care practices with 10 or fewer primary care physicians, primarily based in counties of the 3rd through 6th class, can apply for a grant to support or implement programs to provide integrated physical and behavioral health services in their counties. So I will tell you, the bill does require that the base budget has to every year include certain appropriations to the Department of Health and Human Services for behavioral health services, and a certain portion of that has to be earmarked to these grants. Again, for small practices of 10 or fewer, or for practices that are based in counties of the 3rd through 6th class. So any of you who are in the smaller counties who fall into those categories, start thinking about how you can get grants. Hi, Maria. Haven't seen you in forever. Grants in order to support your behavioral health services. All right, who's next? New topic? New bill? Mr. Chiefs.
Yes. I'm going to go with the other sticker in the bottom corner.
All right, this is a good bill. It's a very interesting bill.
That's what I'm talking about.
And you have a bat. So sorry that you don't have a particularly interesting, I mean, I guess it's kind of an interesting woodland creature, right? But you have a bat, so you also get a prize. You can choose it. You can shuffle on over now or you can shuffle over later. You may have seen me looking at you earlier because I was making sure that was the Kansas City Chiefs and there could be no other Chiefs because I intended to call on you later.
I'm from Greater City. We have a big eye on the mountain.
Oh, that's not the Kansas City Chiefs? All right, thank you. I grew up a huge Kansas City Chiefs fan because my father was, and that was back in the day when I really cared what my father thought. But also because when I was in kindergarten and I decided that I wanted bangs, I took my hair and cut it off like this with Play-Doh scissors. And then my sister made fun of me for my giant forehead, and so I wore a Chiefs hat every day for 4 months in order to hide my giant Frankenstein forehead. So I have a soft spot for the Chiefs. All right, modifications to civil commitment is HB 363. This is a Steve Ellison bill. It does 4 really big things, and this is a very important bill. And some of what was in this bill is stuff that Salt Lake County and other stakeholders, including the Utah State Hospital, designated examiners for the civil commitment process, forensic evaluators for the forensic process, which you guys have probably also heard about, that we worked on for 4 years. And right before the session, our sponsor for our collaborative bill retired. And we had no sponsor to take it up. And I've never begged harder that in any legislative session that I did for somebody to take this up last minute, no one would do it. So instead, we got some of what we wanted into HB 363. So the 4 big changes, first, it redefines what substantial danger is. People who have done civil commitment, why does substantial danger matter? Anyone? All right, very quiet, I will tell you. The criteria for civil commitment, what they have to meet for civil commitment is someone has to have a mental illness that meets the substantial dangerousness standard. And that means that they are right now a substantial danger to themselves or someone else. That can be really difficult, especially when you want to civilly commit someone who's coming out of your county jail. Because hopefully while they've been in county jail, they have become medication compliant. But they need to stay on their medication in order to remain safe and to not recidivate once they're released into the community. So this bill changes substantial dangerousness to include, substantial danger, to include a prong that says they can be a substantial danger if their mental illness is not treated, they might suffer severe and abnormal emotional and physical distress that is associated with a significant impairment in judgment, reason, or behavior, and causes a substantial deterioration in the individual's current ability to function independently. And that makes a huge difference, because if someone needs to be on their medication and they are compliant in jail and they are fine when they are in jail, but you know that the minute they get out and they don't have that daily medication regime, they might slip back into not taking their medication and engaging in dangerous criminal behavior. This is the prong that you can rely on to say that civil commitment is appropriate. This was hard fought, I will tell you, but this is a major change in how you can pursue civil commitment. The second major change in this bill is, does anyone remember a few years ago the assisted outpatient treatment bill? Nobody? So assisted outpatient treatment is kind of like civil commitment, but it has a lower standard. It's one that talks about a person has the potential of future dangerousness if they are not subject to some oversight from the judicial system. And it was also hard fought because who's to say that someone might become dangerous in the future just because they have been dangerous in the past? So it's never been fully utilized anywhere. I think Davis County is the only county that has had really any success with it so far. But we're wanting to use it more. And so this bill added language that said if a county, local mental health authority, or any other person files a civil commitment petition and the court determines that the person does not meet the criteria for civil commitment right now, they can sua sponte, on their own, convert it into a petition for assisted outpatient treatment. And that seems common sense to us, right? If they don't meet the higher burden, but if we're still worried, we should be able to go to the thing that's a lower burden that would help protect them. But that was never set out in statute, and the court commissioners were not comfortable doing that without statutory language. So that was another major change. The third major change was changing the time for a temporary civil commitment from 24 hours to a total of 72 hours. For adults, right now, until this bill becomes effective in a week and a half, you can only keep them for 24 hours on a temporary involuntary hold. This now says that if you have a designated examiner or a medical doctor come in and say, I need more time to evaluate Rob Van Dyke because I'm worried about him and I can't do it in the 24 hours, he can be held for an additional 48 hours on top of the 24 in order to give the examiners in the court the opportunity to fully examine him and make sure that they're doing what is in his best interest and consistent with his due process rights. Does that make sense to everybody? Sorry, Rob.
I'll do it voluntarily.
Okay, Rob is willing to be voluntarily committed for the cause. The last thing it does, and this is kind of unusual, and Utah sometimes does things that are really great. They added in some language that isn't used in a lot of states that specifically says that the person who has been involuntarily committed has to be fully apprised of their due process rights in connection with the civil commitment application, And they have to be given the opportunity to consult with an attorney. They have to be told, and they have to be given the right to consult with an attorney, and within, I believe it's 6 hours, make a phone call to somebody outside of the facility who could be of help to them. And that's 2 different people. So it can also be like, you can also call your mom if that's who you want to call. All right, we need a new topic. Anyone? Don't make me call on you.
Local control.
Lack of local control. The last time I tried this, I referred to it as local control, and people were like, there's no local control. So, all right. Choose a bill.
146.
All right, HB 146. Do you get a sticker? You do. You're a raccoon. Okay. Let me see. That is 2A. Have to just flip to where I am in my binder. All right. HB 146. This bill, it is a little incendiary the way it is written up in your materials, because the person who drafted this is a county attorney with some very strong opinions about this bill. So I'm going to explain it. You know who it was. Rob knows. It was not Rob. But some very strong feelings about limiting health department authority. So this bill is called Local Licensing Amendments. It's from Representative Carrie-Ann Lisenby. And the idea was to make it so that health departments have less control over the regulation of food trucks. Because who needs to make sure that you're not getting salmonella from your lunch from the local food truck, right? Who cares? So what this does is it expands food trucks to include ice cream trucks. I don't know how that got in there. Like, I don't know what that's about, but there's got to be a story. There's always a story behind weird things like that. It restricts city and county regulation and inspection of food trucks. It requires a political subdivision, including a county or a city, to respect the license that has been granted by another city or county, even if their standards, for example, are different. It prohibits local land use or zoning regulation of food trucks, including their size, and out of nowhere, given that this is all about food trucks, it also prioritized the rights of certain ATV business manufacturers, saying that local authorities also don't have the ability to regulate and inspect ATV businesses. And that's just, I assume someone with an ATV business came in and was like, why am I not in here? And they're like, why not? So they were at it. I mean, they really kind of came out of nowhere in this bill, but that's what the bill does. Basically says local health departments cannot do what they've historically been doing with food trucks. All right, who's next?
SB 115.
All right, firearm preemption. I don't even need my notes for this one. This bill, you guys probably know that years and years ago, oh, and you do have a sticker. It's really tiny and small. It appears to be a hairy lizard. It's maybe not the most representative of actual lizards, but whatever, you still get a prize. All right, so firearm preemption was something that was exclusively granted to the legislature by them years ago. And no one really thought this was a thing until Salt Lake County. It's almost always Salt Lake County, you're welcome, or Summit County that causes problems in the legislature. So Jeff knows. We're the stepchildren. So Salt Lake County had a third-party vendor running its convention facilities, and that vendor would, for some people who would come in, require that they do background. So when they would have like firearm shows, they would require background checks of people before they purchase firearms. That made the legislature very angry, and they didn't like it. They really felt like that was treading on what they'd already said, which was, when we mean that we regulate the entire field of firearms, like, we mean it. So what this does, what this does is, I guess I do want to look at my notes just in case I get it wrong. So it makes it even clearer that when they said all firearm regulations belong to the legislature, they really meant it. And it prohibits any local or state governmental entity from adopting or enforcing any ordinance, regulation, rule, policy that inhibits or restricts the possession, ownership, purchase, sale, transfer, or transportation of firearms. It established limits on the possession of a firearm in or near a homeless shelter. And then the new part is the Firearm Preemption Act, which is a new section of code that does create a civil action, a right to a civil action against a local or state governmental entity that attempts to enforce an ordinance, rule, policy, regulation, etc., that they feel like violates the state preemption statute. Make sense? There is an exception. The exception, which is not in your materials, is where a third party who wants to contract and use one of the facilities, they say, I feel very strongly that I do not want firearms in my show. I am told, anecdotally, since I do not know her, that Taylor Swift, for example, requires that there cannot be firearms brought into her shows. And to people who like Taylor Swift, they feel very strongly that she should be able to come to Utah. So there are a few exceptions where if the third party who wants to come and use the facility themselves says, I want this in my contract, that you will not allow it, and it's my request, it cannot be requested by the governmental entity or a third party managing the facility, it's my request, we can accede to that demand. Does that make sense? But if we suggest it, forget it. So practice tip, never suggest it. All right, what's next? New topic? Flowered shirt.
182.
182 gets to local control of local health departments. As it will surprise no one, this was also, of course, the fault of Salt Lake City and Salt Lake County. I, of course, don't say fault in a judgment of my county. I'm just telling you we're the reason behind this bill. So you will recall that in a special session during COVID, regardless of whether one thinks it was a hoax, during special session during COVID, the legislature already said, you don't get to regulate local health departments, local government, you don't get your say in COVID stuff. This is all reserved to the state, except in very, very limited circumstances, because they didn't like mask mandates coming from Salt Lake City, or at the time, I think it was just Salt Lake City, but it was also orders of constraint, like encouraging masks in government buildings and that kind of thing, and they just didn't like any of it. So what this says is that a county that issues an order of constraint legally, and how they can do that is later on, a county that does that can do it, but it does not apply in any state facility. It does not apply at the state capitol, does not apply in any state-owned building. So if someone works in a state building in Grand County and Grand County issues an order of constraint, which would include a mask mandate, it doesn't apply within the state building. Secondly, it says that local city governments have no emergency powers if their emergency is a pandemic. Forget it. And they don't have a local health department. So that was the rationale behind that. Counties do still have some emergency powers in a pandemic. They have to come from the local health department. The county executive can still issue an order of constraint if she or he thinks that's appropriate based on the discussion with the local health department. That can be overridden, of course, by the legislative body in the county, right? And they clarified that if the executive's order, based on the local health department advice, is overridden by the county legislative body, that's not a vetoable override, right? So it's not like the executive gets to come and be like, but no, I liked it. The say of the legislative body is the end of that discussion. Any questions on that one? All right, who's next? Yes?
Law enforcement jails.
All right. It's one of my favorite topics. Anyone who knows me very well knows that I represented, when I was still in litigation, I represented our jail in a number of civil cases, including probably the most uncomfortable case of my 22-year career, and so I have a soft spot still in my heart for law enforcement and for jail. So, choose a bill.
SB 96.
All right. Oh, you have like a teddy bear, kinda? A cute little bear on his paws, so you get a prize. So SB 96 says, I'm just making sure, there's a lot of bills I have to remember, but I'm pretty sure this one is, oh yeah. So you guys may recall that a couple of years ago, Salt Lake County was having a really hard time hiring enough people to be correctional officers in their facilities. So they ran a pilot program where children could be correctional officers, and by children, I'm older now, so I feel comfortable calling 19-year-olds children. It used to be 21. They reduced it to 19 so they could increase their applicant pool. And I'm of course kidding. It actually worked out really well in Salt Lake County. So what this bill did was two things. One, it made it not a pilot and made it applicable to the whole state. So now any county it can hire 19-year-olds. I don't know, I mean, mine's 9, so even 10 years from now, I can't imagine him being capable of dealing with the health and care and feeding of another adult human, but maybe. But, right, you guys, if anyone has a 19-year-old, you know. I know my nephews. But you can hire them, and it means that they can work towards their certification as a correctional officer during that time period, so it just springs into existence when they become 21. Does that make sense? So you can take the examination and you can get ready while you're serving as the 19 through 20 age, and then if you pass, immediately when you turn 21, you become a full-fledged correctional officer. All right? Who's next? Person sitting next to Jeff Buman. Oh, wait, never mind. You're out until next time. John Luthi. Oh, so 406. I heard Will and Tyson talk to you a little bit about this one. And you have a flamingo, so you get a prize. I feel a little bit like Oprah saying that. So 406 was the jail booking photos bill. It does apply to prosecutors. I didn't hear them give you a lot of background on why this was important, so I apologize if I'm being redundant. What happened 2 sessions ago, was that Utah County worked with Representative Kevin Stratton, who is a delight, by the way, if anyone who wants to work with him, he's awesome, in order to make booking photos not public records under grandma. And they did that because of this whole idea of being convicted in the court of public opinion. Once your booking photo is out there, it's out there forever. So the problem that created was twofold. One, it made it so that it was a lot harder to share booking photos by and between law enforcement agencies that were used to sharing those in order to locate or identify suspects. They really felt like once it was in a public document, that became a lot harder, even with a 206 sharing agreement. And does everyone know what I mean by a 206 sharing agreement? Have you guys done that before? There's a section in 206 that says even for non-public records, it's 206 of grandma, sorry. I want to say it's 63 G2 206, could be wrong, but I'm pretty sure that's it. That says that law enforcement agencies and other government agencies can enter into agreements to trade protected records back and forth, and they agree that they do that without waiving any protections under grandma. So even with those in place, it just made it really difficult in order to freely share records that were really important for that. It also made it difficult, and this is the part I did hear Will and Tyson address, for prosecutors who wanted to use 1102 statements and didn't, in lieu of bringing in people to testify in person at preliminary hearings, because it's not a public record anymore, to put their picture on there and then have Rob Van Dyke, who's always going to be my example, Rob Van Dyke say, yes, this is the defendant and this is the person I saw do X. So this year we fixed it, and I feel a little bit bad. Well, I feel a lot bad. Because in that session, they came to me and said, would you be willing to work on the exigent circumstances language that it will allow us to share these even when they're not public? I'm like, sure. So I drafted language that it was specific to exigent circumstances. But a whole lot of times when you need to find or identify a suspect, it's not exigent circumstances. You just need to find the person. So this year, I felt personally responsible. And we did draft the language with Representative Stratton that now loosens the reins on how you can share those non-public records when it's in furtherance of a legitimate law enforcement reason, including to locate or identify someone who is suspected of a criminal activity. Make sense? All right, you. Plaid shirt. What was this? Hodgepodge. These are all just bills that I find interesting, even if they're small. All right, which one?
117.
Oh, well, you have a rocket ship. That's when I ran out of woodland animals, so I had to move to the next sticker sheet that I was trying to get rid of, so you're a rocket ship. That's the address confidentiality program. Will already talked to you about it a little bit. That is a program, and I know that they talked about just being able to hide your address. This program actually goes a little bit farther than that. It has the state issue a fake address to somebody who is the victim of domestic violence, sexual violence, stalking, or human trafficking. The state issues a fake address and a card with that fake address on it. And you can use that fake address if you're a victim falling within that category anywhere that you would use a real address. And so you can register your kids for school using that address. You can register to vote with some important restrictions. You can use it for your utilities. The one thing you can't do is have Amazon send all your packages there, because we were not going to incur the cost of forwarding a whole bunch of packages. But it's a really important protection, because it means not only do you not have to share your address, but government agencies that are subject to grandma, or that might be subject to inspection by a whole host of people, they don't even have your physical address. So that's a really important change in how we're treating this. The one exception for voting, and to the extent you guys are advising, you're going back and you're talking to your victim witness advocates, or you're talking to victims about this as an opportunity for them, the one thing that is a little inconvenient, but we had to do, was it does mean that you cannot register to vote when you get your driver's license. Your driver's license can have your fictitious address on it. And that will be what's in the system. But to register to vote, you have to do it in person at your county clerk's office. And there's a good reason why. Can anyone guess what it is? Is anyone awake to guess what it is? All right, I'll just tell you. It's because the clerk needs to assign you to the correct precinct based on where you live. Like, the voter rolls have to be correct, no matter what. So the clerk will take your actual address to assign you to, or assign your victim to the precinct, but then the voter rolls will show the fictitious address that has been issued by the state. And then in their system, what we worked out with the Lieutenant Governor's office and what we worked out with the local county clerks was they would designate it and suppress it as a withheld or otherwise restricted record, so that when they were printing out lists of voter rolls in response to grandma requests or whatever, that person's home address, their actual address, would never be released. Make sense? All right. Next person, I'm going to go to John.
HB 292.
Well, you know what this letter is, man. Just kidding. All right. HB 292. That is my 2D. Oh, no, that's not right. 292, it's 3D. Sorry, the one bad thing about all of this is having to come up with ways to, no, that's not right either. What am I doing? Is coming up with ways to make sure that I'm getting all the things in the right place. Oh, I'm sorry, I should have just known this off of the top of my head. This is a bill that basically says if you run a micro enterprise home kitchen, go ahead and burn your house down. I'm kind of kidding, but not really. What this did was say that local health departments could no longer require type 1 hood requirements for cooking appliances in micro enterprise home kitchens. And so they're doing a lot of cooking, and the International Association of Fire Code people, or whatever they're called, recommends that you have a certain kind of hood in your kitchen if you're going to be doing X with it. And this says the local health departments can no longer require that. And I'm kind of joking, saying that it burned your house down, but that's why it was required with the local health departments, because they were worried about people burning their houses down. And now they can no longer worry about that. And they do need to update their policies and practices to conform with the new bill. For anyone who advises, if anyone here advises a local health department. Looking at John. All right, who's next?
Elections.
Elections. So this was my 7th year working with the legislature, and I've never seen so many election bills in 1 year. And it is, of course, as a result of the allegations of widespread voter fraud all across the country. We had to address it in all manner of ways. So choose a bill. All right. No sticker. No sticker. All right. All right, HB vote 411. This wasn't one of the more controversial of them. Like the clerk's affiliate with UAC, which is the Utah Association of Counties, tends to be really active in working with legislators on things. But what this does is changing the timing of how you can cure a rejected ballot. So if a clerk rejects your ballot for whatever reason, it used to be that you could correct it up to the day before the canvass begins. And do you all know what the canvass is? Okay, I see Steve Foote nodding. Yes. So that's when they like count and certify the results. And it used to be that you could do that up to 1 day before. This changes it to 3 days before the canvass begins. And it also changes the language regarding how you make contact to verify identity of somebody whose ballot you have rejected, and establishes that a voter has to be directly communicated with. So if I think I'm going to reject John Luthie's ballot, and I'm the clerk, I have to communicate with him directly, and then John Luthie has to provide the election officer with identifying information using the exact same information that is on your voter registration. That's how you cure the ballot. So it makes it a little harder to cure, and it makes the time period to cure a little shorter. Who's next? Do you want to ask for another one? Because let's get you a toy.
Okay.
Okay.
Which one? Let's go with HB 387.
All right. Sticker. This appears to be a green lobster, and I'm not sure where in the woodland green lobsters reside, nor am I sure that it would be a good idea to interact with a green lobster, but here we are. So HB 387 was an interesting bill, and this was one where the clerks, their tight-knit interaction with legislators and with each other kind of fell apart on this one, which was really unfortunate. So this is a bill by Representative Mark Strong, and I do apologize that I have not been consistent in telling you who all the sponsors were. The last one, for example, was Representative Michael Peterson. So HB 3, and I should tell you, address confidentiality, what we talked about twice now, that was Representative Stephanie Pitcher, and she worked on that bill for literally 4 years. And I brought that to her right after she was elected as an idea, right after she was elected, and before she was even sworn in, and it took us 4 years to get it done. But I should give her credit because she worked really hard on that one. And she's a fellow prosecutor, so she's one of you. All right, so 387, it modifies who and how someone can be registered to be a watcher when people are counting ballots, because as we all know, all sorts of shenanigans happen when you're counting ballots. Lots of people steal stuff. I'm of course just kidding, because as you may have seen on Twitter throughout the legislative session, Lieutenant Governor Deirdre Henderson kept saying, like, literally none of these allegations are true. None of this has been established in the state of Utah. They didn't care. So this is one that says if you're going to be watching the counting and processing of ballots, it sort of changed the requirements of how you do that and outlined access to poll watchers. The big part of this bill that was a huge bone of contention is that counties, when they set up the centers where they're counting ballots, now need to make sure that every station in the room, so let's say you have, like, this is where you check signatures, and this is where you double check what box they checked, and this is where you double checked it was received on time, or however you have it set up. There has to be a designated area for as many watchers who want to be there, and you can let in without, violating the fire code, that can be no further away than 6 feet. Because apparently that's the magic distance to detect fraud. So if it is 5 feet, you're fine. If it is 6.3 feet, you are out of line. And there are some criminal penalties that are associated with violations of the election code. So 6 feet was the magic number. That is something that is going to be really hard in small voting centers where they're counting. It also, I have to tell you, like, the whole downstairs, the whole basement, section of the basement under the government center for Salt Lake County is how we set ours up. But we have a lot of different stations. And what we had a municipal election that we administered a few years ago, and it was mayhem down there because people didn't want to stay in their 6-foot area. They wanted to be in this one, and then they wanted to be walking over here where they would be like walking right next to a table. The whole thing was kind of a security nightmare. This doesn't help that. But it does say that the designated areas can be as close as you want, but they can't be farther away than 6 feet. Questions on that one? Okay, how about checkered shirt right there? Yes?
Let's do HB 238.
Where is it? Oh, here it is. This is my hodgepodge, right? And you guys will see I have these numbered underneath, and I don't have a number 5 because it turns out my office didn't have any 5 tabs, so they just go from 4 to 6. So TUR 38, this is a very big, meaningful bill. It is not, however, a big bill in terms of what it says. What it says is for all of you, you get a new state holiday, which is a paid holiday for you. It celebrates Juneteenth, which is the day in the United States that the Black community has traditionally celebrated the end of slavery. And this is now a new state holiday. And I believe this year, I know it falls in June, and I want to say it's June 20th, which I think, you guys are going to want to check your calendars, but I think it makes Father's Day weekend a 3-day weekend. So congratulations if you are a father, if I'm correct on when it is. So you might want to check both. All right, who's next?
Darcy, I think we need to go back to the young fellow from West Valley. How disappointing that is. He comes to his first prosecution counsel and doesn't get a prize. He's never going to come back.
Yes, choose another one.
Let's do human resources.
Human resources, all right. If, for example, you chose this one, you may or may not get a prize.
Yes, ma'am.
Okay. What?
Cheat for it. Make sure he gets a sticker.
Oh, did you not see me just totally cheating in front of the entire room? Right. Not only does he get a sticker, but he gets 2 stickers.
Hold on, Sean, hold on.
Your first victory! All right, so I gave this one 2 stickers because it's a really big bill and it's a really meaningful bill, especially for this group. So HB 223 was sponsored by Representative Wilcox, who is a delight. If you guys have never talked to him, he's wonderful and he's very good to work with. But he had a meeting however long ago with a former chief of police up in the Ogden area, which is where he's from, who was talking about the PTSD that law enforcement feels, and that fire protection workers feel, and that victim witness advocates feel, and like, that's a whole lot of secondary trauma that all of these folks are dealing with all the time. So HB 23 said that for first responders, and then there's a definition of first responders that includes all of law enforcement, and their spouses and their children. So that's important. They have to have access to mental health treatment resources through their employing agency. So if you employ first responders, which will include law enforcement, so for like the Salt Lake County District Attorney's Office, that includes our investigators, does not include our prosecutors. But, well, arguably it does. Certainly doesn't include me, because I'm on the civil side. So I can remain as crazy as humanly possible. But everyone else, arguably, and very importantly, a very expanded list of first responders, they now have a right to access mental health treatment resources through their employer. The other important change there is that same access to treatment needs to be provided to retirees from the agency that employed the law enforcement officer, the first responder, at the time she retired. So if your agency is not currently doing that, you're gonna wanna look at it. I will tell you, in Salt Lake County, we already allow access by spouses and children of current employees through our medical plan, right? Like they can get mental health treatment through that. But we're not quite sure if we're covering retirees in the right way. Like we have an employee assistance program, but there's a definition of what mental health treatment resources needs to be in the statute. And if you have an EAP program or something similar that you think you can just give access to for your retirees, you might want to look at it and make sure that it meets the statutory criteria for what that is, because it's a meaningful thing to do for your retirees. And that's why there's 2 stickers. I see a hand.
Is there any sort of limit on how long you have to provide benefit?
No. So there was a $5 million appropriation associated with this. It's not quite clear to me how they're going to distribute it, but it's going to be a grant program. My guess is $5 million to fund this is not going to last very long, because it's a very big expansion in mental health services to a whole lot of people. And that was a concern with chiefs of police and law enforcement agencies across the state when this was coming up. They were like, we love it. How on earth are we going to pay for it? And so the funding is there, for at least for a while, and it can always be re-upped if we can get it re-upped in future years. There was a lot of money this year, so it was easier to get money than sometimes it is. But that's definitely a consideration that all of us care a lot about. Anyone? All right, you. Choose one. Yes, please.
Let's do SB 40.
have a sticker. It appears to be a little girl in a space helmet. I actually don't know what series of stickers that came from, but I like it. I mean, it's a good one. All right, so 6C. SB40, Utah Protection of Public Employees Act. Has anyone ever had to deal with this act? Anyone here ever do civil work? Okay, we'll tell you, this is a tough act. And not in like tough act to follow way, like it's not great. But they tried to make it better this year. So they gave us a better definition of what an adverse action might be if somebody, like a whistleblower, comes out and says, like, I think Ed Montgomery is stealing from his city. And then Ed Montgomery is like, you're fired. So the person says, like, I was refired in retaliation for accusing Ed Montgomery. Ed's here, and we just went to a training together, so I feel fine accusing him of theft. Because we're not talking about defamation today. So what it does is clarify what a retaliatory action would be. And they're the things you would ordinarily expect in the employee context, like threatening to take away your job title, threatening to reduce your pay, that kind of thing. They also adopt from the civil context what's known as the McDonald-Douglas framework. Anyone know that other than me, unfortunately? Yes, I see. You must have done civil work. Okay.
And that was a law firm.
Oh, got it. So what it's pulled from employment law, so it's not surprising it was adopted here. What it basically says is the plaintiff has to make the original case that she was a whistleblower. Because I'm obviously the person in my scenario with Ed who reported him and he fired. So I have to make the first showing that I'm a whistleblower because I did a protected activity. Then the burden shifts to Ed to say, well, whatever I did was completely justified because it turns out she hasn't shown up to work for 3 months. She sends incendiary emails full of obscenities to employees at 3 a.m. on the regular. And she killed my dog. Then the burden shifts back to me. I would never kill Ed's dog. I don't even know if Ed has a dog, but I wouldn't, I swear. So then the burden shifts back to me to say whatever he just said is pretext. Whatever he said is the justification for the retaliatory action he took against me, like, yeah, maybe I haven't shown up to work for 3 months, but that's not the real reason I was fired. I was really fired because of this, and the burden shifts to me to prove that to the court. So that was kind of implied that that's how it would go, because that's usually how it goes in employment actions, but this bill made it explicit that that is how those claims are processed. Who's next? Come on, someone else wants a prize?
HB 345.
Yes, it's a good one. Hodgepodge. And I see a sticker. It appears to be an alien in a spaceship, which probably comes from the same stickers that I cannot identify for you. So this is the Public Safety Employee Personal Data Amendments. This is Representative Wilcox. This expands some work that a number of us in this room worked on a few years ago for the protection of the personal cell phones, email addresses, hi Steve Garside, and home addresses, cell phones, home addresses, pagers. I don't know why we included pagers, but we did. I guess people still have them. Of people who work in sensitive government positions. So it's judges, it can be prosecutors. We expanded it a couple of years ago to include people who don't fall within a specific law enforcement category, but by the nature of their work might be at risk. So let's say a secretary in the Special Victims Unit might be somebody who would qualify for protection. And it means that government agencies have to protect their records from disclosure under grandma or otherwise. So even when it comes to like county recorders, where they list everybody's property in the whole county and that everyone has their name attached with it, for people who have requested protection under this provision in code, they have to suppress that person's name. The information about the house and its value and all that stuff can be released, but the name has to be suppressed. It now includes, this was expanded the group of protected people. It includes dispatchers, correctional facility employees, and current or retired employees or contractors of law enforcement agencies or correctional facilities. And I will tell you, you guys, that is a huge expansion of the people who were covered by this bill, especially when you get into contractors, because that can be a whole lot of things. So in Salt Lake County, for example, we've had to go back and really think through who we need to make aware that this is available, including, for example, our contracted medical personnel at the jail, to make sure that they're aware this is available to them. And then the burden is on the county, or whatever the government agency is, to create a form that explains the rights to people and is readily available. And if they want to have the protection and you give them the form, you also have to help them fill it out, because they have to designate specifically what records they want to have protected and which ones they don't really care the same thing about. Any questions? Yes.
Does it apply to volunteers?
I don't know. I don't think so, but I don't know. I don't know for sure. I can find out. What agency are you with?
Francis City.
Okay, I will find out. All right. Anyone else? Does anyone want to take a guess, to be the first person to guess?
CLA man.
Yes, you. You get the special prize to be determined. Was that you, the gentleman in the beard and the gray shirt? No, it was you. Hello. That does mean, however, good job. I need your name afterward and the agency you work for, because I have to mail you what I'm going to mail you, my magical gift that I don't know what it is. And it means you get to choose the next one of these, because people are running out of steam, I can tell.
126.
Oh, this is a great one. All right, so 126 is another one I don't need notes for, because it turns out this is one that I drafted. So I'm very familiar with it. This is officer intervention and reporting requirements. This sets out a state standard, and are you guys familiar with the existing constitutional duty that if a law enforcement officer sees someone engaging in misconduct that violates the constitutional rights of a person, they're required to intervene if they can? Do you guys know that that's an existing right? Obligation? And that if you don't do it, you can be sued for it? Successfully. I mean, you can be sued for anything, but you can be successfully sued for it? Who knew that? Okay. That was where my office was about 6 years ago when we were sued for it. And some of my investigators went out to an officer-involved shooting scene, and they were not the investigators. They were not the venue agency. They were there to monitor and participate in the OICI investigation. In that investigation, some officers from a different agency, the investigating agency, took into custody 2 material witnesses who were not suspected of illegal activity, put them in handcuffs, took them down to the station. I'm trying to keep this without identifying any of the agencies involved, and kept these 2 material witnesses, again, not suspected of wrongdoing, in cuffs in the station for about 8 hours. My guys didn't do anything to stop this, nor did they think they had an obligation or the opportunity to do so. But we got sued, and I will be candid, when the case was given to me, my office was like, this is gonna be an easy dismissal. This can't possibly be our duty. And I looked, and within an hour, there's a case directly on point from the 10th Circuit that says, no, it is your duty. So we settled out of that case really fast for a very small fee, and we started doing training on this. And that's when we started talking about putting this into state law, because it turns out a lot of people who work with law enforcement didn't know that this was an obligation. It was in a lot of agency policies, but a lot of people, I think, thought that it was an issue of policy only, as opposed to a significant area of liability under constitutional law. So we put it into state law, and so now there's a duty to intervene if you can safely do so. So we do recognize there's going to be circumstances when you cannot safely do so. And we've defined what police misconduct is. So it's 3 categories. It is excessive force, which is what everybody thinks of. But we had a chief from a local Salt Lake County jurisdiction who felt very strongly that a legal search and seizure needed to be added. And the 3rd category we got because of Representative Stoddard's bill 2 or 1 years ago, I can't remember, that added biased conduct, like based on protected status. We added that in there. And we said that it had to be conduct that a reasonable person would believe was biased based on a list of protected categories. What we said, however, is that you have to intervene, but if you don't intervene, we understand that you might not know that you can, or how you can, or maybe you can't do it safely. So you're not going to be disciplined if you fail to intervene. Like, that's not a subject of discipline. However, you do have to then report it to a supervisor. And we did that because in my experience working with law enforcement, both when I litigated and I represented my jail, and in these years of policy work, is that a lot of times things might happen that are not ideal, but they are also not intentional. They are not, maybe there's a fault in training, maybe it's a new officer who just doesn't quite know yet, despite training. So what we really wanted was not to penalize the officer, but to alert the supervisor that this person might need more training. So for us, it was more of a risk management tool than anything else. Failure to report, unlike failure to intervene, can be the cause for discipline. And that was also important to us because we wanted to make it so that officers, when I have talked to officers throughout the state, and it's been a while because of COVID, but I used to travel a lot more, some of them would say, I'm really hesitant to report, like I never want to be partnered up with so-and-so, because I always know that like shit's gonna go down and it's not gonna be good. Sorry, didn't mean to just swear. But that is the language that was used. So, and they just don't like to be with that person, but they also don't want to be seen as a tattletale, right? Like they don't want to be the person who is saying something negative about a coworker. So we wanted to make it cause for discipline so that the person who's reporting it can truthfully say, listen, I didn't have a choice. And then we made it illegal to retaliate against a person who intervened or who reported. And we made it very clear in statute, and in order to get away from the terrible state whistleblower statute, which if you've ever litigated is a mess, we put in this section of code how claims of retaliatory action would be handled. And we made it so that if you're being retaliated against a coworker, you can report it to the head of your agency. But if you're being retaliated against, allegedly, I should always say allegedly, by the head of your agency, you can report it outside the agency. So if it is a city police force, they can report it to the city attorney. If it is a county police force, they can report it to the county attorney. And if it's any state agency, it goes to the Attorney General's office. And we did that in part because the FOP representative who was engaged in these negotiations with us was thinking of the Heber City situation. And I kind of harkened back to my days when I was the legal director of the ACLU, when people would tell me stories, and my response was always, if that's true, that's terrible. And then you would look into it and like 5% of it was true. And I don't know the facts of what happened in Heber City. And so what I said at the time was, if what happened in Heber City is as reported in the news, and if it's as you're telling us, this group, I get why you would want this protection. So let's write it into law. I have no idea if any of that is true, nor did it matter, because it was a really good point that you should have an outside alternative to report things if there's some reason you can't safely report it in your agency. Make sense? And I will tell you, this is one that we worked on throughout interim, which means the period of time between the last legislative session and then the upcoming one. We worked on it through interim, and we got it to the point where it was supported by the sheriffs and the chiefs of police and Black Lives Matter and the ACLU and Libertas and the county attorneys and the NAACP, and it is the only time in my career that I've had a lot of bills that come with a lot of consensus that I've worked on. This is the only one that had nobody talking against it, and that felt really good, because this is the kind of bill that you really need buy-in from everybody in the system in order to make it effective. But it has the real possibility to, we think, and the primary component in law enforcement who I worked with, in law enforcement who I worked with was Chief Wallentyne, who said he was gonna be here. He's not. He told me I needed to be civil so he'd get civil Staley credit. So I guess now that I've said shit, you guys don't get civil credit. But anyway, he was the primary proponent in law enforcement, and he and I both think that this has the opportunity to make a real change in law enforcement and how people take care of each other and take care of residents. So we only have 47 seconds left. So if you guys want to throw out a bill we can do in 47 seconds, great. Or you can ask me any question you want about literally anything. Or you guys can go to lunch for now 36 seconds early.
Can we go to lunch?
Yes, good question. All right, if you guys have any questions, a bunch of you in this room know how to contact me. I would love to hear from you. If you have feedback on this presentation, feel free to tell me, but it was a pleasure. Thank you very much for playing my game.